Good morning, Carolyn Gramlich with Greg Farrar. We're here today to talk about our mediation program. It's an exciting program, and today we're going to be talking about bridging the gap between our biblical principles and legal issues.
And focusing on the first part of our process, marital salvation agreements. And just a little bit, if anyone has any questions, you can text us with the questions. And we also encourage you, if you feel it would be helpful, to try to call our office and schedule time for us to maybe come out to your counseling group or to your church and discuss a little bit about our program and our process and what we do. And a little bit about myself. My name is Greg Farrar. I'm a family lawyer. I've been a family lawyer for the past 25 years. But within the last year to 2 years, I became a Supreme Court certified family law mediator. And we are transitioning on and focusing our practice on mediation. And we'll tell you a little bit more about that. Carolyn?
And again, my name is Carolyn Gramlich, and I have been practicing law for 5 years. Prior to that, I was an educator, a Christian school educator for the most part, for 17 years. I'm also a Supreme Court certified circuit civil mediator. Very excited to be a part of this mediation group.
And just to lead into the process of mediation, tell our audience a little bit about why mediation is such a much more better model than litigation.
Mediation is so much more beneficial than litigation. Litigation gets contentious, expensive, emotionally draining. It's an informal environment that we have created for people who come to us for mediation. It's a relaxed environment where people can be free to have a snack or get up and go to the restroom. It's not like in court where everything's very structured. In addition to that, parties have the opportunity to make decisions for themselves. And it's a confidential process as well, which is helpful. In court, there's a judge, there are witnesses who come in typically, and very private family matters become public. And divorce litigation leads to a public record. And at any point during the mediation, parties can terminate or dismiss. And ultimately, if there is a decision made, it's up to the parties themselves. And so we feel that the litigation model is not the best model for parties who are dealing with divorce or marital difficulties. We believe that mediation is best because it helps the parties to make their own decisions and control their own future. And that's so much more beneficial for the family and especially for children.
Again, having had the experience of being a family lawyer for 25 plus years, I see constantly couples, and we in the litigation practice, we only meet with one of the parties, and the other party is either represented by another attorney or may not have an attorney. In the mediation process, instead of us being adversarial with each other, and we would, as mediators, be helping both of the couples, and we would not be giving either one of them legal advice, but we would be able to give them legal information. And we would be able to even tell them war stories or things that have happened in our litigation experience that would perhaps give them some insight as to why they might want to avoid the litigation process. But the benefit to the couple is, instead of having to go to two different lawyers and fighting over all these different things, if they go to us as mediators, then we won't represent either one of them. And we would be assisting them in coming up with solutions to help their problems. And the savings as far as costs, money, we can talk about the emotional, which is lifetime problems, but the cost to the family at this very crucial part of it is it's literally a difference of tens of thousands of dollars. Well, the typical divorce, if you want to call it that, for each individual, it easily ranges from between $3,000 to $5,000 minimum, and often $5,000 to $10,000 per individual. So it's $10,000 to $20,000 per couple, whereas a mediation may cost maybe $2,500 to $3,000 total. And so the cost, the benefits of all those things, the confidentiality, the fact that you don't have strangers making decisions, all those are good reasons not to consider mediation over the litigation model.
And Greg, isn't it so much better for that money that is spent on contentious litigation to be spent and filtered back into the family for the needs of the children and the needs of the family itself? One of the greatest advantages to mediation is the preservation of relationships. what we see through litigation is a lot of contention that leads to years and years of strife. And Mr. Farrar has also seen people who come back at the children of previously divorced clients of his with that same contention that has gone from generation to generation. And so we feel that mediation is a way to stop that. And instead of parties taking sides, that people work together. And ultimately, our goal is to assist families in reconciling, and that divorce would not occur to begin with. But sometimes if parties are not willing to reconcile, or if they're not going in that direction, then we can assist them to preserve these relationships through the process of the breakdown of the family.
And what we have currently in this world is a world that's divided, where the real world with the real laws is where couples struggle with, and our faith and our values are completely separated from this world. And in this world, what we deal with is a couple starts to struggle. They have marital difficulties. And invariably at that point, they may talk to their pastor, they may talk to counselors, they invariably will talk to their family and friends. And during that process, we are convinced when they begin this process of considering whether their marriage is going to be successful, that mediation might be the best opportunity to try to resolve their differences before they have hardened their hearts. And what happens in the traditional sense is that the parties start to position each other.
And Greg, a lot of times what happens is people are talking with family and friends, and they're receiving a lot of misinformation about the litigation process, about what it means to be divorced, and what can we do in the mediation setting to assist couples and families to get correct information?
Well, one of the things that we stress is that you be more proactive versus reactive. And in the context of what happens, and I know the counselors out there that are listening, the pastors, all the different warriors in this fight to try to help people save their marriages, they deal with this stuff so late in the game. And that's when the parties have already done so many different things to each other that's outside of what we might have even caused the initial disillusionment of the marriage. Because what happens is the parties start to fight, they struggle, and then they talk to people, and then they say, well, you need to go ahead and take the money out of the bank account, or you need to start doing something with the children, or you need to stop making the payments on the bills of the house. And all those things are now becoming more and more barriers to the potential success or the resolution of their problems, and causes the breakdown of the marriage. The majority of the time, what I see is the people that have already done this. They've already gone through this process. It's been 6 months or a year that they've already been positioning themselves, and by that time their hearts have been so hardened by the different things that they've already done in between the time when they first discovered that their marriage may not be succeeding. And then at that point, it's so hard to try to save it because they've already made up their minds. And so in the traditional marital settlement agreement, this is one on the screen that we would use in a traditional agreement. This is probably after months and months of fighting. And what happens is basically the parties have decided they're going to divorce. And this is a difference between what what we're offering and what a traditional mediation group would offer. And in our traditional marital settlement agreement, the parties have already acknowledged in that whereas clause. And go ahead, Carolyn.
And the whereas clauses in the typical or traditional marital settlement agreement are, there's already a presumption that the marriage cannot be fixed or that it's irretrievably broken, which is a standard under Florida law. And so that language reflects parties who have given up. And so what we would like to propose is a marital salvation agreement where parties are given hope for reconciliation. Sometimes when we put in writing what our intentions are, it becomes sort of an indelible impression on the mind. This marital settlement agreement, that's the traditional model, once parties see in writing that it looks like their marriage is not going to succeed, it's really an avenue for them to lose hope. And so what we want to do is present a model that would allow for some hope for reconciliation. And if not reconciliation, for at least reconciliation of their relationships.
And a very good pastor told me what happens is that we do words to each other and we get bucketfuls of words. And it's the oral stuff we say to each other, the fighting, and we load up our buckets with that kind of stuff. And what we as an attorney do, we say, look, get it in writing. Because, the bottom line is, if you think about it, up until the marriage license is about the only thing in writing that the couple receives at the beginning of a marriage. After that point, they may have made oral promises, which are usually not enforceable. They usually don't consider the consequences. Oftentimes, marriages are begun, with just maybe a hope, sometimes a prayer, but never anything in writing that gives them anything that they would have any legal consequence about.
And Greg, and the marriage license is very limited. There's no accountability in the marriage license. People rush down to the courthouse sometimes, get married before a judge or justice of the peace, and they go their merry way with very, very little accountability in writing.
And in this world, it does matter when you get it in writing. And just something as different as the previous slide, which basically is marital settlement agreement, and changing the title of this to marriage salvation agreement matters. Mm-hmm. And because it matters to the couple. When they read it, they realize this is something that this is a binding document that they will have to follow. And if they don't follow it, it will give them, that there will be consequences. And in this marital salvation agreement, which is new, novel, look it up, try to Google it. I mean, when we came up with this program, this plan, we couldn't there's nothing out there. And I know as a divorce attorney, I've never done that. Never have I suggested to a couple when they came to see me, why don't you see if you can save the marriage first? And this would be something that we could work hand in hand with the pastors, with the counselors, with all the people out there that are trying to help this couple try to save their marriage. Coming up, instead of us being the tool for the ultimate demise of the marriage, we can actually be the tool to help them save the marriage.
And Greg, this is legally binding. This is a legally binding document, just as any contract is. And courts are about the business of enforcing contracts. Otherwise, contracts would have no validity.
And that's a fact, and we can put consequences in there. And these whereas clauses, whereas unhappy and unfortunate differences have arisen between the parties, which the parties wish to attempt to resolve through the foregoing salvation plan. That language alone is, if the couple agrees to it, gives them a legally binding document which they can then use with their counseling, with their other service, with their other plan that they have in place. They actually have changed what was the traditional to the new, and this gives them an opportunity to try to save their marriage.
And the marital salvation agreement, Greg, is more in line with our biblical principles, isn't it?
And that's exactly why we believe it so strongly that this is one opportunity, one possibility that must be explored and won't be explored without the help of the pastor, without the help of the counselor. Because couples, they won't come to this on their own conclusion oftentimes. Most times in this world, we throw everything away. And marriage has become just another commodity that's thrown away. And we all have heard how this world has become one where this is a broken thing, I'm going to get a new one. We don't keep anything. And marriage has become that, guys. And the only way to try to save it is to put strength back into the marriage. And the laws have not given strength in marriages. The laws have done the opposite. They've done everything to make marriage and divorcing so much easier and less consequential.
And Greg, Florida is a no-fault state. Explain
cool.
what that means.
No fault means that if either one of the parties believes, for whatever reason, it doesn't have to be for any reason, that the marriage is broken and it can't be fixed, they can get divorced. It doesn't mean that's what no fault means. No fault means that it doesn't matter whether you want to remain married and the other party says I don't. If that other party that says I don't says that, then they can get a divorce.
And there's no accountability whatsoever in that, is there?
None. There's no accountability. And in fact, the laws have become less and less helpful to trying to preserve marriages. That's why they need to come up with these agreements. So that's why, in fact, on another webinar, we're going to discuss marriage contracts, prenuptial agreements, another avenue where you can actually perhaps put teeth into a marriage at the beginning of the marriage so that the marriage would be much more likely to succeed because they have to, because it's legally binding. And that is something that we just need to consider, and we'll talk about that at another time. this terms of reconciliation, this is a document that is not included in the standard traditional marital settlement agreement. And this is a clause in portions of the agreement that the parties can agree upon to try to come up with a way to save their marriage, which will be a legally binding document.
And Greg, these terms of reconciliation can be determined on a case-by-case basis. We're giving some examples, 4 examples of possible terms of reconciliation, but every case, every family, every situation is different. And so we can tailor make these terms of reconciliation to suit the needs of the family and the couple who come to us for assistance through this mediation.
At a minimum, couples need to agree to a counselor, to a method of counseling, and come up with maybe a plan and a duration for counseling. And then they need to deal with any of the other issues that may have caused the breakup, including drugs or alcohol or any other, so many, the reasons why parties fall out of love are as numerous as the stars in the sky. And everybody has a different possible reason. Ultimately, it's about satisfaction or dissatisfaction. And what it all boils down to ultimately is parties don't realize that marriage means something, that marriage does matter.
And it has value. Marriage has tremendous value in society because marriage and families are the foundation of our culture and our society and community. And so when the family breaks down, the entire community and subsequently the society has a breakdown and problems. And we see that today, we see the results of it today. Single parent families and crime rates that have accelerated and so on.
So this is an added document an added provision in the marital salvation agreement, which is different from the standard marital settlement agreement. And this would give the parties an opportunity, a legally binding method to try to resolve their differences with integrity, with knowing that they're attempting as good faith, making the effort to try to save their marriage, which is typically not done in these when it gets to a mediator / litigator lawyer. And in addition to that, we would also deal with all the other issues that give rise when a couple starts to have difficulties. And this is where the positioning by the parties can be avoided, where they take their children out of the fight.
And in divorce litigation, we use a peace model, the acrostic peace. We deal with family matters such as parenting, equitable distribution of assets and liabilities, alimony, child support, and everything else, including things such as attorney's fees and costs. Those are matters that all are discussed and negotiated during the litigation process, and those issues are also to be addressed through the mediation process as well, from a different perspective, from the perspective of preserving relationship, causing couples to amicably settle their issues and differences, and again, ultimately, for reconciliation of the marriage.
And these are all the minefields that I hear from the pastors and I hear from the counselors are constantly becoming the issues that while they're trying to help them struggle with the relationship issues between the husband and the wife, these things come up. And if they're not resolved earlier in the process through some type of marital salvation agreements, through this mediation process at the front end, even as the counseling is commencing, not at the back end where they've already made these the issues of the case. And these would be the things that they could resolve now on a temporary basis and allow them to reconcile, to work on their problems, work on the things that has caused the initial breakup of the marriage. And so they take their kids out of the fight. They can come up with a parenting plan. They can deal with who's going to live where while they're effectuating their reconciliation, how they're going to support each other, how they're going to support their kids. And all those parts of it are opportunities that causes marriages to break up because those become the problems. And they can't even focus on whatever was the original problem, because these problems are the ones that then become the most important, because it's dealing with, well, where am I going to live? How are my kids going to deal with this? And so we take all this out of the fight and let them come up with their own solutions for these issues to allow them to focus on their relationship. And so that's what a true marital salvation plan could do, is give them an opportunity to put all this stuff that would cause the fighting out of the way and let them come up with their own way to deal with their issues. And I can't stress enough how important it is to do this at the front end of the process, to try to come up with a. I know there's a a huge barrier that a lot of the pastors and a lot of the counselors that we talk to, particularly those Christian based that that believe as we do that marriage should be preserved, that then when they send somebody to what we traditionally were, which is divorce attorneys, they feel like they're already leading them down to that path of dissolution. And what we are trying to do is explain to the public, explain to the people listening that that's not what we intend to do. And if they can be sent to us with one, the understanding that they are coming to us as mediators only and not litigators and not family lawyers, and two, that they've been prepared by the counselor, by the pastor, to try to come up with a salvation plan, then with those two things from coming to us, then we can do what we're explaining about today, which is coming up with that plan. But without your help, without your preparing them to come to with that intention, then we can't do anything without you.
And the Bible instructs us to bear one another's burdens and so fulfill the law of Christ. And going through family difficulties, divorce, that's a tremendous burden on a family. And as Christians, we need to come together and assist one another. Galatians chapter 6, verse 10 says, "As we have therefore opportunity, let us do good unto all men, but especially unto those who are of the household of faith." And so we believe that doing good is helping families to see the benefit and the value of marriage and of reconciliation as opposed to divorce and divorce litigation.
And I know we have a couple of webinar questions, and I believe one of them was, what's the difference between mediation and going to court, Carolyn?
And we have talked about that. I think mediation provides for so much more flexibility for the parties. As Greg mentioned, when we litigate, the court, it's really at the court's discretion as to when the hearings are going to be. So we have to look at the judge's calendar, and it's really at the judge's convenience, not the party's convenience. And then when we go into hearings, everything's pretty rigid, and we have procedures that we follow in court, and that provides for very little flexibility. But with the mediation model, that there is quite a bit more flexibility. The parties, this is one of the greatest advantages, the parties themselves are in control of the outcome, and they can determine for themselves whether or not an agreement is going to be reached. The court in litigation will determine what kind of agreement is going to be reached, and in mediation, the parties have all that control. They can either reach an agreement or not.
And so I know we've kind of covered mediation. We're going to have other webinars where we can talk more about the process and describe what mediation is like here at our firm. A question's been asked, exactly explain the difference between what we're offering as far as a marital salvation agreement versus the standard marital settlement agreement. Carolyn, would you like to start with that?
A marital settlement agreement is going to be pretty standardized. The language will be standardized. It's really, like I said earlier, it's kind of, in my opinion, defeatist language. It's just that this is what's going to happen. We can't get along. The differences between us cannot be resolved. And so therefore, these are the things that are going to happen as a result. With the marital salvation agreement, it's a whole different approach. It's the parties putting in writing their attempt or their best attempt to reconcile and to work out their differences. And at least then they have a written record, no matter what happens in the future, there's a written record of their specific attempts to resolve the issues that are prevalent in their marriage or in their family.
And I guess I mentioned it earlier, we're in a society where if you don't put it in writing, that's why I have clients call me and they'll say, Greg, somebody said that they're going to do this. And I said, okay, that's good. I'm glad to hear it. But, and particularly if it's something that I don't think that is likely going to be accomplished, I invariably tell them, please, just tell them, put it in writing and have them sign it. And then that's a legally binding agreement. And within the context of marital difficulties, when parties are having difficulties, oftentimes they make promises that they don't keep. And I know that's been a frustration for counselors and for pastors and for the different courageous people out there that are trying to help couples get through this process and to try to come out the other side in an intact marriage. And the difficulty is they don't get it in writing. And the difference in the marital salvation agreement is that we put the terms that they agree upon in writing, and we also put consequences. And so, for example, if they don't do this, this is what may happen. And again, it's not what we say. This is what they come up with together. But we would help them facilitate to come up with a legally binding document that has consequences. And that is different because there's not anything out there that does that. In the marriage divorce arena, the lawyers, we've been focusing on ways and methods to make it easier to divorce. And instead, you can actually do the opposite. You can come up with an agreement that makes it more difficult to divorce. And again, it does require the couple to agree.
And difficult in the sense that there are going to be some pretty serious consequences in the event of divorce.
Exactly. And you could put financial remedies. You can put a variety of different things in place that would actually be encouragement to do the right thing, to do the thing that they're trying to do to try to save their marriage. Whether or not couples will be willing to do that, that's a great unknown. And I guess that's a test of a person's true principles. And if you believe in certain things, if you have certain values, and that's a given whenever couples are communicating, and that's if they don't agree, then this process won't work. But if they do agree, and if they want to try to come out of this with integrity, with a sense of knowing that they did what they could, that they tried their best, and then they want to use these methods to accomplish that goal, then that's what a marital salvation agreement can do, which a marital settlement agreement does not.
And it also, Greg, what it will do is it'll create an accountability record for the couple. You know, sometimes if we are facing consequences, that can act as the greatest deterrent to doing possibly the wrong thing.
So true. And so I invite you, any listeners or any people listening to this, if you have questions regarding any of these issues, to give us a call. And I'm going to take a couple more questions, and then we're going to conclude this webinar, and we'll announce what we have for subsequent webinars. And these will also be available on YouTube, and also we can email you webinars if you have an interest in finding out more about any of these things. One of the questions that was asked is whether or not there are any statistics involving this program and or mediation in general. And in general, let me say that in the family law arena, basically only about 10% of cases are actually litigated. However, 100% of the cases that go to lawyers are, at least when parties hire different lawyers, all of those cases, at least as far as the lawyer is concerned, are litigated cases for the point of having to go through a process. The cases that actually go in front of a judge is only about 10%. But then the other percentage that are with attorney involvement go through a process of litigation. And so out of those, most of those cases are required to be mediated prior to going to litigation or prior to going to a final hearing. And so this mediation process is attempted at least once throughout this, prior to a trial. We are suggesting that you do this mediation process much further earlier in it to try to make it come up with a better result and save money. But at some point, you're going to go through a mediation process. Statistically, just a national average, 70 to 75% of all cases mediated are resolved at mediation. And so that's I guess the main statistic we can provide today. We have no specific numbers regarding this marital salvation agreement because, quite frankly, it's so new. We've only been able to form this program, this process, within the last year, and we've actually been focusing on transitioning and encouraging this mediation process. So those listening and those who are hearing this message that feel like this would be a method that they think they would like to at least attempt for themselves, their family members, for their congregation, for any of the members of their church to try to resolve their differences at an earlier stage in the process through this, then that's who we're trying to meet. And we'll see what God provides. We'll see if this doesn't work. And we do believe it will work. So that being said, God willing. Carolyn, did you want to mention anything else about any future programming or any final thoughts?
Yes, we have a series of webinars in addition to this one that'll be up and coming, and we hope that you'll be able to join us. We're excited about this very unique and innovative mediation program, and we feel it can be very successful. And the family is the basis and the foundation of our society and our community. So when there's a breakdown in the family, there's essentially a breakdown in the community, and it weakens the community ties. And so we're hoping to strengthen the community and society through this program.
That's very true. And in this society in 2013, United States of America, we're going through so many different struggles and so many different times, and our families are faced with so many different challenges.
Families are under attack.
And we believe that to be true. And we're hopeful that this process, this program that we're offering, may be one of the defenses against that attack, may be another offensive weapon that we could use to stop this attack upon our marriages and upon our families, and where we can perhaps come up with a better way to try to make our families more secure, safe, happy, and healthy. And so with that, we hope everyone does well today, and God bless you.